Mr. Sutton,
Yes.
it's my understanding you're outside.
Yeah. I'm right outside the court.
All right. At this point in time, Mr. Bannis, who is your attorney and who is going to remain your attorney unless the court says otherwise, unless you've retained counsel, is going to go into a breakout room to meet with you. Do you understand that, sir?
Yes.
All right. All right, Mr. Bannis, do I need to call the Sutton matter so you can play something on the record?
Yes, thank you, Your Honor.
We'll call the case of the state of Michigan versus Kobe Sutton, S 0387.
Kyle Burdell for the people.
Andrew Bannis with and on behalf of Mr. Suddeth. Kobe, could you say your name, please?
Kobe Sutter.
Thank you.
So, Your Honor, we're here on a MDOB charge. I have discussed this case with my client. We had some defenses we were ready to assert at trial today.
Your Honor,
Not yet. You can't. Don't talk over anyone in court, sir.
okay.
The prosecutor has an offer and has suggested he might be adding an count 2. I spoke with Mr. Suddeth. He has told me he wants to represent himself in this case. I've advised him that I would prefer to help him and represent him, or he has the opportunity to hire private counsel. But he has told me he wants to represent himself in this case.
Thank you. Mr. Sutton, you may now speak.
Yes, I feel like I should represent myself in this case.
Sir, just so that you understand, you can represent yourself in this case. That is against your attorney's advice. It's against, it's probably a bad practice for you to do so, but that is your choice. The maximum penalty in this case right now is currently 93 days. The prosecutor has indicated that if you go to trial and there's testimony to actually support it, that he intends to add a count of resisting, obstructing a police officer. That is a misdemeanor carrying a maximum of 1 year in the Washtenaw County Jail. So this case does carry jail time. Do you understand that, sir?
Yes.
And so given all of that, you still want to represent yourself. Is that correct?
Yes.
All right, we're here for trial today, and we will be moving forward with a trial today. I'm going to appoint Mr. Bannis as standby counsel.
Okay.
So if you want to represent yourself over everyone's advice, you can choose to do so.
That's what I choose to do.
All right, we'll do that. When we're done with this next trial, you can wait out there in the lobby until we finish this case, and then we'll begin your trial. Okay, sir?
Thank you.
Mr. Bannis, I've called the case.
I'm here, Your Honor.
Please place your appearance on the record as standby counsel.
Andrew Bannis, Assistant Public Defender, as standby counsel.
All right, we are here in this case for a non-jury trial today. I am calling the case a second time just to make a record, Mr. Sutton, over the advice of Mr. Bannis, who is his attorney, and over the advice of the court, is choosing to have a trial and self-represent himself. Is that your decision today, sir? Please speak up.
Yes.
And you understand that this carries jail time, and that is what you're choosing to do. And I've advised you that if you are found guilty of the felony, of the misdemeanor that they want to add, that is a 1 year maximum penalty, sir. No, I told you that they want to add a charge, which is a resisting, obstructing a police officer, attempted, which is a maximum of 1 year in the Washtenaw County Jail. They want to add a charge, if the testimony provides, of attempted resisting and obstructing a police officer, which is a misdemeanor carrying a maximum penalty of 1 year in the Washtenaw County Jail. And you understand that, sir? All right. And you understand the offer that's been made today? Mr. Burdell, could you repeat the offer, please?
There's no person fee is charged. If the defendant fees is charged, the malicious destruction of the building less than $200, the people will agree to no upfront jail time and will not add additional charges. For the record, Judge, in transparency, the deputy is not here at the time. He is on a domestic violence call somewhere in Lane Township, I believe. However, I expect and I hope that he is able to get here in time for the trial. We may not end up hearing from him today. People have elected to proceed anyway. I did want that to be open for the sake of transparency since we are discussing it.
So to complicate matters, you have somebody who's self-represented. And now the offer that you're making may not be an offer, because if the officer doesn't show, then really there's nothing you can offer because you can't make out the proofs, correct?
We'll agree to no upfront jail time that we plead this charge. But that is correct, Judge. I may not be able to hit the proofs if the officer is unable to.
All right. So if they are not able, if the officer doesn't show up, because the officer can show up anytime during this hearing, sir. If he shows up and he testifies and he makes out those proofs, then you're looking at 1 year. You understand that? I'm sorry, what? Who to be a witness? Who are you referring to as a witness? Well, if it's resisting obstructing, he's actually a victim. That's the way that works, sir. If you don't follow the rules of the order. I'm not going to get into what the trial is with you. You can choose to do what you want to do. I'm telling you, it's probably not in your best interest, but you can choose to do that. That's not how this works. You don't get to tell a story. What will happen is you'll take the stand, and then Mr. Burdell will be questioning you when that time comes if you choose to waive your right to not testify. I know you don't know how it goes. That's why you shouldn't be representing yourself. Because it's probably not in your best interest to be saying what you're saying. And you don't recognize that because you don't know the law. Okay, well then you can know a little bit about it and choose to do what you want to do. But when it's not in your best interest, you can't say that no one told you not to do this. Is that still what you want to do? Well, you don't tell a story. You get to answer questions. That's correct. That's the way it works. Yes, and you'll be answering his questions. Everybody is here to answer questions. No one gets on the stand and tells a story unless it's through questioning, sir. And since you don't have an attorney, that's going to be able to question anybody. Are you questioning me now?
No, I'm not.
It sounds like you are.
No, you probably don't know because you weren't there. I was there. The officer was there. Jack, I think we're getting an argument here.
Yeah, I believe we are definitely getting an argument.
This is going beyond scope of attorney or not.
Do you want an attorney or not, sir? No, what I want to know right now is whether you want an attorney or not. And I'm telling you that the procedures you think you're going to use is not the way court operates. No, you don't get on the stand and just tell the story then either.
Whatever I do.
I'm not going to continue to argue with you, sir, and you're not here. But you are, and we're done with that. Do you want an attorney or not? Mr. Burdell, he is now requesting counsel, which I think is in his best interest, so that his attorney may be able to explain to him how this process works if he wants to be able to get his story out, because the way he's planning on doing it is not going to work. So you need to not interrupt me again. So Mr. Bannis is clearly in a different place. Is it your intent to, I think at this point in time, it appears that we're gonna have a difficult time with Mr. Bannis representing him from where he is.
Judge, here, we're ready to go. Our witnesses here, we discussed trial strategy. Based on her schedule, her getting down here, the people opted to take the risk of not even being able to pursue one of the more serious charges here. This was requested by the defendant, and so, Judge, we're ready to go. I understand there may be a technological issue, however, this was procedure chosen by the defendant. So we're asking to proceed. Judge, absolutely ready.
Mr. Bannis, what is your request at this time? He wants the attorney appointed, and so given that we're in the same day, I'm just gonna put you back on this case. So what is your plan?
Thank you, Your Honor. I was prepared to do the trial today. I was prepared to be there in person. Mr. Sitta told me he absolutely didn't want to counsel. He didn't provide any explanation. I was perplexed about that. I discussed the offer with him. His response to that was he did not want counsel. I'm sorry I'm here by Zoom. Over the past hour and a half, I could have been down there in person. I'm asking if we could reschedule this, and I'd ask my client to waive in person.
I'm not gonna ask him to waive in person. He wants to do this in person.
Okay,
He's
well,
entitled
I'm
to
asking
it.
for an adjournment then. Otherwise, I'm ready to proceed.
Yes, sir. Sir, I'm not trying to make you plead guilty. You misunderstand what's happening here. That's not what I'm trying to do. I'm trying to make sure that you're properly represented, first of all. And then secondly, I'm trying to figure out how to deal with our technological issue. And I never want to make anyone plead guilty to something that they say they didn't do, as long as they understand all their options. But going to trial as a self-represented person is, quite frankly, a stupid thing to do. Okay? And so now I'm trying to figure out what to do about that now that we're in this situation. So give me one moment, okay? Mr. Bannis, you are half an hour away.
Yes.
Hold on one second. So if I have Mr. Bannis come down here, are we all willing to wait for that?
Yes, Judge.
All right, that's what we're gonna do. Mr. Bannis, you need to come down, sir. All right, everybody can go back to their respective corners in the hallway, and then we'll start this trial when Mr. Bannis gets here. Half an hour, sir. Half an hour. If you don't come back, there'll be a bench warrant.
Yeah. I don't want-
Okay, thank you.
Vashon, this is an application. Court is calling 2023 CR 3506, State of Texas versus Desiree Allison Gutierrez. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Christopher Castro for the defense.
Are you Miss Desiree Gutierrez?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Gutierrez, I'm going to show you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Gutierrez, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
You're charged with the offense of driving while intoxicated with a child under 15. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
So, Ms. Gutierrez, just so you know, paragraph A is also a state jail felony and paragraph B is a state jail felony. And both are the same charges, except in paragraph A, it has the correct name of the person who was under the age of 15, and paragraph B was the incorrect name of the person who was under the age of 15. Do you understand?
Yes, Your Honor.
And I say that so that you will know that if the state were to decide to waive paragraph B, paragraph A is still a state jail felony with the same charge. You understand?
Yes, Your Honor.
All right. All right. Did you understand you have a right to jury trial?
Yes, Your Honor.
A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Ms. Gutierrez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 120 hours of community service restitution, and 1 year driver's license suspension. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Your Honor, I submit State's Exhibit 1 in the attachments.
No objections.
All right, and you may continue to confer.
Thank you, Judge.
All right, after reviewing state exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
None at this time, Your Honor.
All right. Are you employed?
Yes, ma'am.
What do you do?
I'm a sales representative for Taskus.
For what?
For Taskus. It's like a kind of like a call center, but I work in the as a sales representative for a client.
All right. How often do you drink?
Well, that night was like New Year's Eve, but I don't drink that often.
Well, how often is not that often?
I want to say maybe like on like the weekends or like every other weekend.
Do you realize what could have happened in this case?
I feel really guilty about it.
What could have happened in this case? other than your 4-year-old and 6-year-old being killed? What else could have happened?
I could have hurt somebody else.
Yes. And because what I'm reading here is, first of all, you were driving too fast on Hebner and Vance Jackson. And then you did a wide turn and you drove the wrong way. So at that time of early morning hours, when it's dark out, and I don't know why in San Antonio, there are some places that there are no lights and it's super dark. And somebody else could have been driving and you could have had a head-on collision with them.
Yes, Your Honor.
And then not only did you do that, then you accelerate more, drive in the dirt on a grass median, and almost ran head first into a light post. What were you thinking celebrating New Year's Eve and having a 4-year-old and a 6-year-old out that early morning hours?
I wasn't, Your Honor.
And why would your cousin, because I'm reading this, your cousin allowed you to leave, so surely they could tell that you were intoxicated, or were they intoxicated as well?
I'm not sure, Your Honor.
Let me just explain something to you, and I tell this to people all the time. I don't drink alcohol. I just don't think it tastes well. That's why I don't drink alcohol. But if you have plans where you're going to drink alcohol, I don't care if your plans are to drink one drink at dinner. Always have somebody who's going to be the designated driver. Because when people are intoxicated, their reasoning flies out the window. Everybody who's intoxicated who decides to drive don't think they're intoxicated or think, well, I'm only going 2 blocks. I can make that. You almost killed your children or seriously injured them. You almost killed other people. Do you understand?
Yes, Your Honor.
Is this your first DWI that you've been charged with?
DWI, yes, Your Honor.
I know this. I'm not even going to ask, but I know this is not the first time you've drank and drove. So that's going to have to stop. When you're on probation out of this court, I'm going to follow your agreement, but on probation out of here, and it's throughout Texas, sometimes people think I'm being mean when I tell them you can't drink alcohol on probation. Those are the rules across the board in the state of Texas. If you're on probation, you cannot drink alcohol. Doesn't matter if you're at a barbecue, and I know July 4th is coming up and people think that's an excuse to drink alcohol. You are not allowed to drink alcohol. Do you understand?
Yes, Your Honor.
So who's taking care of your children right now?
They're dying.
Okay. All right. This is what the court is going to do. Court is going to sentence you to 2 years in the state jail facility, suspended and probated for 4 years. There's to be regular reporting by Zoom or in person, regular UAs, DWI intervention, VIP, ignition interlock for half the term. I'm going to want a TAP evaluation. And if the TAP evaluation recommends inpatient treatment, we'll start with intensive outpatient treatment. I'm going to want 90 meetings. Have you been doing sober meetings?
Not yet, Your Honor.
All right, I'm going to want 90 meetings in 90 days. 120 hours of community service restitution. I'm going to order parenting classes. And once she completes those parenting classes, the community service hours will be deemed to be completed. And she can do that with rainbows. 1 year driver's license suspension. And probation, we'll do one field visit. And if all seems well, then probation, you can have field visits as many times as you choose. There's going to be a $500 fine that will be probated. Probation, is there anything else she needs? Thank you. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Is there anything else, probation? Is there anything else you need from the court in order to be successful?
No, Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, I did, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction. You're not allowed to own or possess any weapons or ammunition. All right, we can go off the record. Here's the thing. When you have children that are the age that you have, everything that they see, they mimic that. And they will now think it's okay. So you need to let them know that you made a bad choice, that it won't happen again, that you're sorry for putting their life in danger. And parenting classes will teach you that.
Yes, Your Honor.
All right, because your children are 100% dependent on you. And if something would have happened where you would have killed somebody, who knows, maybe you would have been in prison and your children would have been without you. Or if you would have died, your children would have been without you. Or if your children would have died, you would have been devastated.
Yes, Your Honor.
Okay. All right. So you're going to do better.
Yes, Your Honor.
All right. Here's the thing in this court, communication is key. So if there's an issue that you have, ask probation. Probation will work with you. If you feel like probation is not addressing some issue you have, then just come to the court. We're here Monday through Friday. Okay.
Yes, Your Honor.
You have any questions about anything?
No, Your Honor.
All right. Good luck to you.
Thank you.
You're welcome.